This is Constitutional Rights in Black and White. This is a story about an old and important American judicial institution. Nope, not that one. This one, the municipal court. These courts are created and operated independently by cities and towns and villages, so they are profoundly local. They go by many different names, including city, town, summary, justice, mayor, and police courts. Unlike their state court counterparts, they have limited jurisdiction, which means they only hear misdemeanor cases and local ordinance violations, and sometimes small civil claims. Because they're local and because they only hear low-level cases, municipal courts don't get much attention, but they should. They might look small, but they are actually a large and influential part of our legal system, our criminal system, and our local governance structure. First, there's the sheer scale of the phenomenon. There are over 7,500 municipal courts nationwide. That's about 3 times the number of state trial courts. And most states have them. 29 states permit individual cities to create and manage their own local criminal tribunals, to enforce local ordinances, and to raise local revenue. Municipal courts come in all shapes and sizes. Some courts are large and run sophisticated operations. Some are small, with hardly any resources at all, and operate out of police stations, garages, or even barns. Some municipal judges are lawyers, many are not. Some courts operate on the record, some don't. And these courts do a lot of work. Every year, municipal courts process over 3.5 million criminal cases alone. That's not including millions more traffic and civil matters. Municipal courts also collect over $2 billion in fines and fees, revenue that is relied on by courts and cities and states. In other words, municipal courts are a big part of the criminal system and a big part of local democracy. For all these kinds of reasons, these thousands of low-level, low-status, often underappreciated courts could not be more important. The rest of this video is taken from a webinar that I moderated in 2025. In conversation with 3 other experts on various aspects of the American municipal court phenomenon. Blake Strode, Executive Director of Arch City Defenders in St. Louis, Missouri, the historian Professor Laura Edwards at Princeton University, and Judge Andre Sparks, the presiding judge of the Municipal Court in Birmingham, Alabama.
I've been honored to be the presiding judge for the city of Birmingham, Alabama for the last 14 years. I've been on the bench now for about 29 years in various capacities, but I've been happy to be in this space because I believe it affords me the greatest opportunity to help people in our community. In Alabama, we have 67 counties, but we have 280 municipal courts. More municipal courts, of course, than we have circuit and district courts. We have a prosecutor who is a prosecution staff that's typically out of the city attorney's office. And we also have a defense counsel appointed by law. Each court has to have an indigent defense counsel staff. And even though the law in Alabama for indigency appointment of indigent counsel specifically excludes municipal courts from creating their own indigent defense counsel, City of Birmingham mirrors that law when it comes to creating its own indigent defense team. And so the City of Birmingham is invested fully in making sure we have a full staff of indigent defense counsel to represent the parties who come before us. Every type of social ill you can imagine is first seen here at Birmingham and our municipal courts, every one of them. But we also hear hundreds of domestic violence cases, hundreds of DUI cases, hundreds of assault cases each and every year. I believe municipal courts afford us the greatest opportunity to help people at the very beginning of the problems they may have. And because of that, the city of Birmingham has adopted the same standards that the county courts have in terms of accountability. We have had at this court a drug court since 2008. We have had at this court a veterans treatment court since 2011. In fact, both of those were the first in the state of Alabama. Well, the Veterans Court was the first in the state of Alabama. Our drug court has been awarded almost $7 million in federal grants to help people with drug addictions. We believe that if you're going to come to this level of court, we need to try to, no pun intended, arrest the problems you have here so that you do not move on to a higher level of involvement in the criminal justice system. That, I believe, is the greatest opportunity we have.
So on August 9th, 2014, when Michael Brown was killed by a Ferguson police officer, there ensued, as we've referenced a couple of times, a globally infamous racial justice uprising here in Ferguson, in the St. Louis region, a slew of state law and policy changes focused on the municipal court system in the state and in the region, a federal Department of Justice investigation that really was a full-throated indictment of the local legal system in Ferguson and by extension in St. Louis County. Dozens of federal and state lawsuits focused on that system, most of them brought by my organization, Arch City Defenders, and in collaboration with other co-counsel and other organizations. And sustained media coverage, reporting, public pressure, and really vocal critique of this system of legal fragmentation that we have in St. Louis. And after all of that, from 2014 to today, we went from 81 municipal courts to 85 municipal courts. Then we are definitely of the view that municipal courts are an engine for criminalizing poverty. This has certainly been my experience and observation. If you walk into a municipal court docket, and I've walked into a number of them, you will overwhelmingly, at least here in St. Louis, you will overwhelmingly encounter people living in poverty. You will be hard pressed to find a wealthy person in municipal court who's not an attorney or a judge. And why is that? Because municipal courts primarily function on financial sanctions. And so for most middle class and wealthy people, the relationship with municipal courts is that they occasionally get tickets, they occasionally pay tickets. And that's sort of the end of the story. And so for our clients, the most common offenses that are trapping them in these long-term engagements are things like failing to maintain insurance on a car because they can't afford it, or failing to keep a properly maintained, registered, and tagged vehicle, again, because they can't afford it. We serve a lot of unhoused clients, and there are a number who are in court for loitering or trespassing charges because they're unhoused. I think it's really critical to keep in mind that there are multiple entities that can profit depending on the setup. And again, this does vary greatly from one place to another from municipal court systems. And here we can think about private probation companies, electronic monitoring, substance awareness programs, and all of these private interests are totally dependent on the coercive power of municipal courts to get their customer base. And so it creates, again, some really perverse incentives that don't really have anything to do with the institution of justice.
I'm going to take you, as you say, back into a very strange world that is very distant from us. It's the late 18th and early 19th century in the United States. And at that point, there are not many municipalities. And so municipal courts actually existed as part of this really dense landscape of a variety of different kinds of local courts. And so these are below the jurisdiction of states. They're often below the jurisdiction even of counties. And they're focused in on justices of the peace and the more amorphous kind of areas that they serviced. Here are two concepts. One is this idea of the peace. So this is a legal concept at the time. We actually still with us today. The concept is that the justices, the justice system generally is designed to uphold the peace of the public order. The second important point here is the concept of police powers. So today we think of police powers and we think police powers belong to the people who are designated to be the police. In this period, there are no policemen. There's no police force anywhere, and especially in rural areas. And that's the case in rural areas into the 20th century. Police powers are seen as lying with the people. So this whole system is dependent on people's responsibilities for upholding the public order. Judge Sparks was mentioning that he sees a lot of domestic violence cases. You see domestic violence cases quite frequently in these local courts, municipal courts in the late 18th and early 19th century. And, conventional wisdom is that married women were not able to bring these kinds of cases, but they were in these very localized situations. And they did as members of the public order, as complaints against husbands who were misusing their authority and violating the public peace as a result. You would even find enslaved people bringing cases, not cases in their own names, but they would make complaints to a justice who would then bring perhaps that complaint, turn it into a public matter because it was an offense against the public order. The enslaved person could not bring the complaint, but they could provide information, and then somebody who could then prosecute the case would do this. So it is an interesting world where, as I said, people were responsible for this justice system. The justice system was also very responsive to them because it was embedded in these communities of people who knew each other. If we imagine people are on the outside of the legal system, they're actually really on the inside. And there was this deep knowledge of how you investigate a case, how you make a complaint, that you needed to show up, that we were all responsible for creating the communities in which we live. And there's something really, I think, interesting and hopeful about that piece of our history, of that community responsibility, of that sense that we can actually solve these problems in a way that makes sense for us all. And that was the institution where that happened.
I feel like we could write a history of the United States and the US justice system through the lens of this conversation. We've engaged the problem of discretion, which haunts our criminal system from policing to prosecution. We've engaged the rock and a hard place that we have created through, I'm going to say it in academic terms. Blake said it much more clearly than I do, but sometimes we call it the criminalization of the welfare state, the idea that we have converted our understanding of community support into a thing that we give people when they are criminalized, that now the burden falls on judges and on courts to provide a thing that the community used to have some sense of responsibility for providing. And it's one of the sources of dysfunction of our criminal system that we have placed this inappropriate and unfulfillable burden on institutions that are not designed to carry it. So we have voices from within the misdemeanor system, the criminal system, in these spaces of municipal courts, pushing back against the destructiveness, even as people recognize this deep history of a history of communal accountability, the potential for communal accountability, and as Judge Sparks showed us, places where some courts and judges are trying to make that a reality, even in the face maybe of contrary or unsupportive state law and funding policies. So we're telling this rich story of so many aspects of our criminal system and its intersection with our social system, which is all by itself a reason for us to take municipal courts extremely seriously.
I think that this notion of community accountability is really key. We talk about that a lot in various spaces and in organizing spaces. And I think we have sort of lost the thread on what it means as members of a community to be accountable to each other and to be accountable for each other. And we've tried to outsource that to a criminal legal system, and that has some obvious negative ramifications. So I appreciate that history that you laid out and think there's a lot to learn from that.
Okay, I was thinking the conduct that's being swept into municipal courts isn't always being swept into municipal courts because of municipal courts, but because of the way we police things. And municipal court simply becomes the basket that catches all of these situations, much like schools catches a lot of the social ills. Never intended to be that way, but it always goes back. It also goes back to what the professor was talking about. The public has abrogated its responsibility in a number of areas. And because of that, trying to create peace and keep good order, we have, I think, inappropriately placed responsibilities in places like municipal courts.
And I think one of the most important things that I found in some of these courts is the amazing possibilities that people on the margins advocated in the context of these courts. And so, married women thought that actually getting beaten was a problem and they wanted to do something about that. Enslaved people had questions about the way they were treated. Poor people had questions about how property was distributed. People came and talked about land use. I think that all those things were top of mind at this point, and there's a real regulatory tradition in our country dealing with all these kinds of things, and also a history of community involvement that I think could be rescued without taking the bad parts of that system along with us, because we could create a better context now.
I just want to end by thanking our panel. This was just an extraordinary conversation. It's just not a conversation that we've been having. And I hope to be in conversation with you many, many times again in the future. Thank you all so much.